everybody for participating and attending. We're going to be doing this at least once a month. And what we're really trying to do is just pull together and garner ideas and exchange information in the intellectual property and business structuring space. We'll have a number of different special guest speakers. Today's special guest is Albert Caddy from the United States Patent Office. And with that having been said, I'm going to turn it over to Emmanuel to get it going.
All right. Once again, thanks, Ron, for the introduction. We'd like to welcome everyone who decided to take part in this webinar. We have with us this morning, I'll let them introduce themselves. As those of us who are on video, you can see them. They'll speak for themselves in terms of introduction. We'll start with Mr. Boyer.
I'm Leonard Boyer. I'm going to be speaking on the types of corporate structures for businesses in New Jersey and a little bit of the pros and cons of each. And I'm Emmanuel's law partner.
And we also have with us today, again, this is Mr. DeCady.
Hi, good morning, everybody. My name is Albert DeCady. I have a disclaimer. As I work for the U.S. Patent and Trademark Office, today I do not represent the Patent and Trademark Office. Any opinion that I express today will be my own and my own only. So we'll be talking about trends in intellectual property.
Okay, now I'm just happy. Good morning, everyone, and welcome. We are going to set the context of this webinar, the discussion that we are having today. And it's not any legal advice that we are providing. This is just a webinar, and it's really a 10,000 foot of where the patent law is in the United States. We will start by setting the background, the context for our discussion. And this is just a reminder, and I'm sure all of us, we know that in 2013, we went from America Invent Act to, from first to invent to first to file, which made a huge difference for startups, small businesses, and people who are sole inventors. The first to file is just what it says. Whoever files the application first gets it. And so that started the race to the Patents Office, as it was called, and anticipating all the issues that the startups and small companies would have in terms of resources. The Patents Office created a new category in terms of fees to get access. They came up with the micro entity, which is, it used to be, you have the small entity, the large entity, and they introduced the micro entity. The Patents Office also started quite a few initiatives in order to help the cash-strapped or the funds limited type of entities, such as a small startup business and individuals. Which includes having collaboration with universities to provide assistance to pro se people who are prosecuting their own applications. You know, as a point, in fact, we have here on the slide that Walmart claimed priority to 37 provisional applications. That was back in September 2016. Where they have an invention to a cart, to a self-driving shopping cart. But every time that, throughout the process of developing the invention, every time they came up with a change or a significant change, they went ahead and filed a provisional application. And it costs money to file provisional applications. So you figure that you had to file 37 provisional applications. Let's assume it at $1,000 each. That's at least $37,000 just, and you haven't gotten your non-provisional file application yet. So that is the impact that that it has on well, people of all stripes, including large corporations, because I'm sure Walmart wouldn't have to spend that much money if they didn't have to. And so now that becomes part of getting the patent. So that's the background that this discussion today will be had. Okay, we will now go into the different areas of IP. Then we have patent, copyright, trademark, trade secret, and we'll start with patent. The changes that occurred in patent, starting with Alice v. CLS Bank. This is a case, and here I'm going to ask counsel to jump in and help me out with the effects of Alice v. CLS Bank and all its progeny regarding 101. And maybe we should define what 101 is for counsel.
So yes, so the 101 provide the entry door for an invention to get in the patent office. So it says basically whoever invent a machine, product of manufacture, process, and improvement thereof can have a patent. So exactly what falls into these four doors is a subject that that's been very litigated. 2014, the court pronounced a new test under Alice, and I don't know how deep you want me to get in right now, counsel, but you know, that test is the law of the land and has created quite a havoc in what is considered to be patent eligible and what can have a patent. I guess later we'll get a little bit more detail on that. I want you to get through the process now.
Okay, thanks. Now, I guess we should say that we kind of jumped ahead because the Alice really, well, no, it applies also during prosecution because you will get rejections on your patent applications. But in any event, now let's move to artificial intelligence generated invention. Lately, we all have heard of machine learning, robotics, and artificial intelligence generated
Emmanuel, we had a couple of questions in this area.
I'm sorry?
So we had a couple of questions in this area before we move on to the next topic. Mark asks, what happens if someone started as a micro entity, but now filed another application that makes them small? Do the earlier application now become small?
Well, no. I mean, micro entity is based, there are certain criteria that you have to meet in order to qualify as a micro entity. So long as at the time when you did file your application, you were a micro entity, then you were a micro entity. And down the road, circumstances changed, and you now become a small entity, then it falls under small entity. It's really fact-based.
And we have another question. So how does the small guy compete in the new world of first to post or first
to file?
Yeah.
Well, that's thanks for the question. That's a good question, and that's why we decided to launch this webinar, because we know that the small guy is having a lot of difficulties in order to compete in this new landscape. This is my own opinion. This is what I would say is that, again, the small person would have to use all the different types of ways to raise funds. Nowadays, as we all know, you have all sorts of ways that you're able to raise funds in order to proceed with your project. They did liberate the laws regarding security so that it's easier to raise funds over the net. Or again, like we said, the Patents Office had initiated some ways, I would say, to help people who are cash strapped. For example, if you are in New York area, for example, they have a center, I believe, that you can go in and where they can provide you with help, and those free legal clinics that can help you out. But in any event, you're still going to need some funds of your own in order to really compete in this new landscape. I don't know, Counsel, if you want to chime
in. No, not at this point. Sorry.
Okay. All right. So the small entity really is facing some hurdles in terms of getting their patents nowadays. Yes, definitely. There are ways. Maybe we should. The next webinar should be about how the small or the cash-strapped inventor can compete in the new landscape. We'll take note of that. But thanks for the question. That's all we can say right now.
Sounds like a hot topic. Okay,
yeah.
so you're going to move on. You have 5 minutes more before we're going to switch to Albert.
Okay. But all right, then that doesn't leave me much. But anyway, we nowadays under the new regime, which is the first to file, again, it's well, you know what, artificial intelligence, I didn't really say much. We know that nowadays people are getting into artificial intelligence and inventions that those robots create. And there was a recent case where there was this gentleman who filed an application at the Patents Office and requesting that the robot be named the inventor. It didn't fly, and so I'm sure Albert will talk more. So I'll move forward. I don't have much more time to say much about that. Now, again, as we say, Alice or the new first to file also makes it easier for the public to provide prior art to the Patents Office during the prosecution of an application, which makes it a lot easier for the application to be rejected. And once your application is allowed or issued as a patent, there now is this new post-grant review, which is administered by the Patent Trial and Appeal Board. Although it was implemented to really ease the small entity, but it's still expensive. It's about $100,000 or so to really go through the patent, the post-grant review at the Patent Trial and Appeal Board. So the person or the entity which does not have much money, again, face a huge hurdle. Let's now move to copyright. DCMCA, the Digital Copyright Millennium Act, is being reviewed by the Congress to make changes when it comes to when, for example, when someone receives a takedown letter due to, let me back off and just say, with eBay and Amazon, nowadays, it makes it easy for people to really post or sell over the internet, e-commerce. And so there's been a huge number of takedown letters being sent, and it is affecting affecting the small guy. And so the Senate, Congress is looking into making changes, especially also regarding what happens when you receive a takedown letter. And then there is the Google versus Oracle, which is called the the case of the century, and it affects software, especially interfaces. How that's going to play out will determine how software is regarded. How much time do I have left?
I'll give you another 5 minutes because I inadvertently asked you questions, and we really should have saved all the questions to the end.
Okay. Now, as for trademark, there's been a few changes in terms of scandalous and offensive trademarks, such as Washington Redskins, and there was a mark FUCT, and the Supreme Court says that now it's fine to have a team named the Washington Redskins, even though it does offend. It goes into the territory of traditional knowledge. We're not going to get into that, but it does offend traditional knowledge. And now Congress has to go back and say something because the Supreme Court ruled that it is against the First Amendment for the Patent Office not to allow someone to have a mark such as the Redskins, or the Washington Redskins. And then the latest in trademark is this case where nowadays you don't need willfulness in order to get someone's profits who infringe your trademark. The Supreme Court just ruled on that not long ago. When it comes to the last category that we will briefly touch on is trade secret. As we all know, trade secret used to be a state affair. Nowadays, since after the AIA, trade secret is now federal. So you now have a federal cause of action when it comes to trade secret. I'll stop there, and we'll take questions later. And thank you all.
So thank you very much. Now we're going to move on to our guest speaker, Mr. Albert D.
So good morning. I do not have slides, but Council Coffey had asked me to expand on Alice. In 2014, this case came to the Supreme Court. Obviously, prior to 2014, the court decision was issued in 2014, and the subject in this case was whether the question posed to the court really was whether the issue, whether certain claims about computer implemented electronic was patent eligible. In this particular case, there was an escrow system for facilitating financial transactions and using a computer system. Whether that was statutory under 101, and the court in that case decided that it was not, it was an abstract idea, and also kind of expand on giving a two-pronged test, how you would know if something was statutory. One, the first prong, you actually would look at whether it is it claims some kind of an abstract idea. An abstract idea could be math, something that is mental, and some other criteria that could fall into abstract idea. And then if it's implemented on a computer, whether that computer was generic, or whether that computer addition, or not just computer, but computer other elements that worked in the claim made it in such a way to move the abstract idea from an abstract idea to something that could be manufactured and make a difference. So, so this test is what is being used in the courts to determine whether a particular claim should get a patent. Obviously, claims were issued prior to 2014 that had become a patent. They found themselves quickly having to defend them. Some of them were upheld at well, the courts were flooded in the district courts about cases trying to invalidate different patents based on 101. Some of them were found ineligible, and some of them were found eligible, and soon they were appealed to the CAFC, which is the Court of Appeal for subject matter, for patent subject matters. And that court from 2014 to today must have issued about at least 150 decisions. Don't quote me on that. But it's certainly a large number of body of law that has been where the court is wrestling with what is patentable and what is not patentable. There's a lot of details in those claims, and you can start differentiating what is statutory and not what's not statutory. But it is still considered an unsettled area of the law where there's still quite a bit of litigation in this area of challenge. I will not comment on how the Patent Office addresses 101, because that would ask me to expand on policy issues, which I cannot talk about policy of the office. I do not represent the Patent Office today. If you are interested in 101 and how the Patent Office handles it, I would suggest that you go to www.uspto.gov. I'll type it in the chat in a few minutes, but it is www.us, like United States, patent, and T for trademark, O for office.gov. Let's see. So remember we said under 35 USC 101 was the entry door to the patent system. If you can't pass that minimum threshold, although the Patent Office will give you an examination on everything, but if you can't pass that threshold, you cannot get a patent because it's considered non-patent eligible. And those four categories again are, I'll read the full statute here. 35 UNC reads, invention, whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof, may obtain a patent thereof, subject to condition and requirement of this title. So if you don't fall within one of these categories, obviously abstract idea is not one of them, then you won't be able to get a patent just based on 101. So that's that has been the highlights of intellectual property for the past 6 years now, and everybody's trying to draw a bright line where it's pretty much impossible to actually create a bright line on the subject matter. But the court decision from the CAFC are would be very useful study to help delineate where the line could actually be. I'll take question at this point.
Okay.
Any questions from the audience?
Oh, sorry about that. I was on mute. The first question is, what is Alice exactly?
Yeah, so Alice is just it became the name of the it's the name of the company that actually was in subject to that decision. So it's Alice Corporation versus CLS Bank International. That's the case that bubbled up all the way to the Supreme Court. That in that decision, the court gave a new test to decide whether something is abstract or not. It's now known as intimately as Alice.
Thank you. Would an online marketplace with a new process be an abstract idea and therefore not patentable?
I can only answer this in general. So let's look at the Alice case again. The Alice case was an escrow system. So you're creating an escrow. Hopefully you're familiar with an escrow system. That's when you want to buy something and nobody, you have a buyer and a seller, but none of them want to trust each other in the process. So you go to an attorney or a bank and you put an escrow. You say, well, the money is in the bank. And if you actually do what you say you're going to do, you're guaranteed your payment from the bank. And the bank says, yes, we have the money. You can start the process and so on. Except that in this particular case, this was being done electronically, right? So you're creating the same concept that was known to men practice in person to person. You move that to a marketplace or electronic platform. And the court said in this case, no, that is an abstract concept and cannot be patented. Because remember, again, a patent gives an exclusive right to the inventor. So you would have actually excluded the public from being able to use something that they already have in their hands, which is to create escrows. And just putting something electronic, at least in the court decision here, they felt that the abstract idea was the concept of the escrow, which been practiced, and then it was being run in a general purpose computer where it did not change the structure of the computer at all. The computer was doing what it was supposed to be doing. And in that case, the court said that was non-statutory. So to go back to the question, and the way the law works is that you analogize your current situation with what the courts have already discussed, and you see similarities, and then based on those similarities, you can kind of gauge whether yours is going to fall within the bucket of non-statutory or the bucket of things that may be statutory. There is no bright line rule, although practitioners in the field have over 6 years of the body of law and the different discussions and different type of invention. They're starting to get a sense of where that line is and draft their claims accordingly.
Thank you. All right. We can have some more questions at the end. I want to thank you for your time. I want to now move forward with Leonard Boyer to discuss business structures. And after Leonard gives his presentation for the next 15 minutes or so, then we'll have some final question Q&A and the webinar. You're on, Leonard.
Thank you, Ronald. Hopefully everyone can hear me okay. I'm going to talk about the different types of business structures in New Jersey. These structures are also applicable in other states. However, state law is different from state to state. All this time and investment is not going to help anybody unless they have the right business structure. The choice of business structure is critical for the success not only of your business, but also to protect your personal and family assets, excuse me, from potential creditors. The choice of a business entity also will influence how you can raise capital. Now, the worst possible business entities are sole proprietorship, which offers no protection whatsoever. The income is not pre-tax. It's just passed through to you, and you can be personally liable should a creditor or anyone else have a lawsuit against you. The other type of problematic, even more so, is a general partnership. General partnerships, like sole proprietorships, have personal liability. They give you no corporate protection as other forms of business entities will do. So in a general partnership, let's say you have 2 or 3 general partners. Each are jointly and severally liable for the actions of the partners both within the partnership and the consequences of that. The income is ordinary income, not pre-tax income, and you're exposing yourself to unknown people. Frequently, a general partnership is not in writing, although it should be. Anything involving more than $500, or that there can be suits pertaining to what happened in a business transaction, should be in writing. The next bad thing is a subchapter S corporation. This also offers pass-through income and no real protection. The subchapter S is the accountant's best friend. It's like other types of corporations, but there's a tremendous amount of paperwork and reporting, and I've seen several companies have to go bankrupt both personally and business-wise because they had no protection. This is the type of entity that's set up by accountants because it gives them the most work, and it gives them ample opportunities. The reporting requirements are excessively burdensome. Now, the 2 corporations that I favor can be used together. Everybody's probably heard of the C Corp, which is designated by the words INC at the back of it. A C Corp has no personal liability for the members of the company. The C Corp can issue shares, it can raise capital, and it has the most requirements as far as reporting, but those can be done with the help of an attorney. So your C Corp enables you to sell stock, not just to the immediate members, but to the general public at large. And you can raise money in a variety of ways. An angel investor who is usually associated with the first round of funding a business is going to look at the corporate structure so they don't have to worry about losing their investment. This gives you the best form. Your liability is limited to your investment. If you think of most companies on the stock market, those are either incorporated companies or they're limited liability companies. Now, the limited liability company is easier to set up. It has to have at least 3 members, otherwise it'll be treated as an alter ego. So you never want to have a single member LLC because it's very easy to pierce the corporate veil. The corporate veil, in case you haven't heard of it, is the insulation between you and any personal liability. Now, if you have a 3-member LLC, it's not treated as an alter ego. Now, the C Corp and the LLC can be used in conjunction. So let's say you're an inventor and you've got patents for various different type of uh, of your ideas, different products. Each product can be in a separate LLC. The LLC should only have one or two products at a time. The LLC should also be owned by the C Corporation. Now, there is an issue of double taxation, but there's nothing stopping, with the advice of a business attorney or a CPA, on setting up payments from the LLC to the C Corp to manage the LLC. And if you're in a business where you may have developed a successful business and you want to sell it, but you don't want to sell your main corporation, you can just sell the LLC. Now, each business, no matter what type it is, has to be recorded with the state, and it must be regulated. It must be registered with the federal government with an and you need to obtain an FEN number from the IRS. That's a Federal Employment Identification Number. You also need to choose and reserve a company name for your business, no matter what entity you choose. Also, you have to, with the current state of commerce today, every business has to have a website or it's not going to exist. So in the eyes of Google and other search engines, and that's critical. So you want to have a business and you want to have all the possible domains for that business. There are numerous extensions to domains. It's not just .com, .net, or .org anymore. You can have .legal, .usa. Literally, the sky's the limit. So you want to choose a business name, and then once you've chosen that business name tentatively, you want to go and take a look on a search engine and find out which names are available. And you can have all the domains linked to one central domain so that you have all the business and inquiries from that. But that's a separate, more complicated topic. So you want to reserve your business name. You want to then determine if the business name you want has domains available that would support it. And then once you do that, once you have registered the business name, you purchase all those domains. And you need to also have for your business general liability insurance, and we can guide you with that and determine what else you should have. But at a minimum, you need general liability insurance, and you need to have workers' compensation insurance. If you're going to have your business owning vehicles, then the business should have the appropriate commercial vehicle insurance, whether it's an automobile or some other type of vehicle. The key is to have everything properly insured, so you want to be as judgment-proof as possible should something happen.
Ron?
Yes.
Yeah, I'd like to tag along an idea or an issue that Lenny brings up. It's this idea that every company nowadays, you have to have a website, which is true, right? But it also brings about this notion of an IP portfolio. In other words, you're just not going to have a patent application, but you'll have patents, you'll have trademarks, Like, for example, your website domain can now be registered as a trademark. So you're going to have a portfolio consisting of a variety of intellectual property. That's the idea.
And that's a very important point, Emmanuel, because otherwise you could get into the whole issue of cyber squatting. You could have, say, one or two domains that you think of for your business, and somebody else can look and say, oh, gee, I can get these others. And if you want them, you would have to buy them from the person who's bought it. And several people make a very nice living from doing that. I'm not advocating doing that, but can you imagine if Pepsi or Coke or any other major corporate entity like Apple or Google didn't have all the domains associated with their brand under their ownership, how much somebody could get out of them to try to get
well, that's actually where that's actually where it started. I've been doing the internet since there was an internet, and Burger King had to literally buy BurgerKing.com. So back in the day, making those investments in domains was a very lucrative business. They've changed it since then, but I have to ask you though, with regard to all of the domains, that can run you over $1,000 per year. Do you think that that's should you get a bundle of domains that are the most important ones? And then
I would say, it's going to depend on the size of your business. So I would recommend, there are ways to get discounts on domain registration. I use GoDaddy for all my domains, and I have about 40 domains. They're not all active websites, but these are the domains I think I will need. And then I can expand out as I choose to. And a choice of a domain, which could be a whole subject in and of itself of a video, is critical, because you want the domain to reflect your business, to be SEO friendly, which means search engine optimization friendly, but also you want people, you have to know a lot more, and that's where a webmaster comes in, or marketing companies that specialize in your type of business, as to how to get you well known and have visibility. And that in and of itself can be the series of an entire course. Marketing of any business is revolutionary, and it has to be, in my opinion, multifaceted, because depending upon the economy, some aspects of marketing will work while others are not. So if you're running a retail business, you need an e-commerce website. You may need a brick and mortar website, or you may end up choosing a drop shipper so that you don't have to maintain inventory. But the risk with drop shippers is in many cases, they don't label, you put your label on that. So the person who's receiving the package can find out, as one of my friends did years ago, who the drop shipper is. So the person selling the product and having it drop shipped loses out on future business.
No, that's excellent advice. I've had many people run into that. Because once you get that address, then when the buyer wants to do it again, they just bypass the distributor, the person that introduced them to the drop shipper.
So you go back to the days when, not before Albert Gore invented the internet, but when Vincent Cerif invented the internet.
I actually have one of my partners actually did invent the internet. He created something called TCP/IP, which is the internet protocol by which all the computers talk to each other. He
Yeah.
created it in 1996. So
I,
he said Albert Gore was not there.
I remember very well the precursor to the internet, which was the computer bulletin boards.
Yeah, it originally started for engineers and scientists. So I went to a college that required, it was the first college in the country to require everybody to have computers. And so when you got your computer, and we went on to this thing called DARPANet. And that was the defense.
Mm-hmm.
The defense's version, but you actually literally had to know like Unix as a programming language to know how to communicate across it. But that itself is a whole different program. So we have one last question here. Can you run an LLC as a C Corp, or is it always better to create a C Corp?
No, what you have to understand is those are two different entities. The C Corp should own the LLC. So let's say, I'm going to give you an example from real estate because it's easiest to illustrate the concept this way. ABC Corp is the parent company, and you're a real estate investor. So you buy a property at 123 Main Street, and that becomes 123 Main Street LLC. You buy another property that's 456 Smith Street, and another property that's 789 Place, Anytown, USA. So each of these LLCs is owned by the corporation. So if this puts two layers of insulation between you and any problem. Remember, the LLC must have three members, a managing member and two other members. Now, when you have, go take it further with the real estate example, you can sell either the property out of the LLC to a purchaser, or you can sell the LLC itself. But let's say something happens until you sell that LLC and somebody gets hurt. Well, you would know if you've spoken with me that you have to have general liability insurance on that property as well as workers' compensation insurance. So chances are there'd be no personal liability. But let's say the injuries were unforeseeable and there was an award that exceeded the amount. They can't touch your C Corp and they can't touch your personal assets because that LLC can just file for bankruptcy without affecting the other LLCs and without affecting your C Corp. To a certain extent, again, in consultation with a tax attorney and a CPA as to what's legal, the LLC can bypass some amount of double taxation by paying the C Corp a management fee. And the C Corp would have to do some actual management of the LLC to justify it. And the more money you can spend using pre-tax dollars for things you're going to need anyway that have a legitimate business purpose, you're better off spending those pre-tax dollars. So your C Corp can own, let's say, a truck that, say a pickup truck for simplicity that has the name of the C Corp on the truck and can transport stuff to the job site at the LLC again. And the pickup truck can be used in a manner that's legally appropriate for tax purposes. But but this way you can lease it, not own it, turn it in at the end of the lease so that you don't end up having to pay for repairs out of your own pocket or out of the business's pocket.
Okay.
Outstanding. We have one last question, and then we'll be wrapping up. What are the best ways to protect yourself against piercing the corporate veil in a one-member LLC?
You don't want to have a one-member LLC because it's almost automatic that the corporate veil can be pierced because it's treated as your alter ego. You need 3 members for an LLC, and you need a managing member. Also, another very important point, which I didn't bring up, is that the LLC must have a separate bank account of its own, checking and savings, or just checking. But you cannot mingle your personal funds with the LLC. So if you have a car repair and you're a one-member LLC or a 3-member LLC, and you write a personal check for your car repair, that's mingling your personal funds with the business funds. So you want to have a separate business account for the LLC, and you want to have a separate personal account and separate accounts for the C corporation. So an LLC on its own, while it's popular in some professions, is generally not a good idea in most businesses. Your best bet is a C Corp that owns the LLC.
One last question snuck in there. Can these members be family members?
The members can be family members, but they all should be above the age of 18 or 21, and you have to have a managing member, and you have to set up the right insurance so that if something happens to them, they're covered. And that can be the subject of, just like internet marketing can be the subject of an entirely separate webinar. The money you spend on insurance is a form of, it ensures you sleep at night peacefully and that nobody has to worry. Because if you have an LLC, it has to be 3 members and it has to be properly insured. But the cost of your insurance is a tax-deductible business expense, but it can save you, it can save your life literally, financially and emotionally. And especially in this age of COVID, nobody knows what's going on. By the way, just as an aside, Governor Murphy signed an order amending the corporate act, amending the corporation laws in New Jersey so that corporations can have their annual meetings virtually during the COVID pandemic.
Wow. Well, as a person that sells PPE, I don't like that. But anyway, thank you very much. I'd like to wrap this up. We're going to be having this once a month. I think this was a very intelligent and insightful conversation. We will take this recording and send it out to everyone. We'll send a link to the recording, and we'll also send information on how you can contact the different individuals to discuss services and or drive down into different information with them.
All right, well, let me summarize then.
If I could also add just first, before Mr. Coffey summarizes, if you're interested in specific future topics for these webinars, let us know, let Mr. Coffey and myself know so we can put together additional webinars to address those topics if there's popular interest in them.
Great.
Yes, as part of the email, if I can just, as part of the email that you will receive with the video, you'll have a survey about this particular webinar and a place to submit additional topics for future webinars. Sorry, now Mr. Manuel.
Thank you. To summarize, we went over the America Invent Act as a gate, as a starting point, I should say, as the reference point where everything changes from first to invent to first to file. And we went over all the categories that and the initiatives that the Patents Office undertook in order to help the small business and the solo inventors. And we also spoke about the race to the Patents Office that the AIA brought about, and we also to illustrate we spoke, or we cited Walmart, which had to file 37 provisional applications before finalizing with the non-provisional application. So that can be very expensive. We went over, and specifically, we went over Alice VCLS Bank and its progeny, and the result on 101, USC 35101. We also spoke about artificial intelligence generated invention, that now, as of now, a robot cannot be an inventor in the United States. And we also believe in Europe, because I think it was declined in Europe. We spoke about public protest, how it makes it very easy for the public to send prior art to the examiner examining a certain application, which makes it easier for the examiner to reject the application. And we also spoke about post-grant review at the Patent Trial and Appeal Board. On copyright, we spoke, DCMA is undergoing review at the Senate IP committee. And we also spoke about this case of the century, which would affect software interfaces, Google versus Oracle. On the trademark, we spoke, we addressed scandalous and offensive marks. FUCT was one of them, Washington Redskins. And we also spoke about this case, Romag Fasteners versus Faso Group Inc., which allows people to now get an infringer's profits without willfulness. And in trade secret, this has long been known that trade secret, you can now have a federal action for trade secret. That each one of these topics can be a subject for a webinar. So we went very quickly over them, and we appreciate your attending this webinar. Again, as we've indicated, you could let us know a subject that is of interest to you, and we will research it and hopefully turn it into a webinar. Thank you, Ron.
So thank everyone for attending. We will now be shutting the webinar down, and you will receive the information with the videos and the survey within the next 5 days. Thank you very much.